Hello, everybody. Thanks for joining us today for what's going to be, I think, a really interesting conversation around college sports and NIL. It's obviously a hot topic. We're all hearing about it on a daily basis. I think many of us don't actually know what's happening, though. It seems like it changes regularly. And we've put together, I think, a great panel today to talk through what's the latest, some of the key challenges, some of the key issues, and maybe a little bit of what to expect in the future as we continue to see, really a massive transformation in college sports. So, to kick things off, I'm going to introduce our moderator today, Jackie Beaudet. Jackie is the Executive Vice President, General Counsel at Galway and at Epic. She is in charge of the company's risk and directing compliance, but she's also been instrumental in a lot of the sports business around Epic and Galway as well. So Jackie will introduce our esteemed panel, and I'll turn it over to Jackie here in a second. One little bit of housekeeping as the conversation continues. If you have questions, the way we're going to manage that is to post them to us in the Q&A feature. And at the end, if we have time, I'll pick a couple of questions and come back to the panel and ask them through that feature. So again, if you have questions, put them in the Q&A app and we'll manage it that way. So without further ado, Jackie Beaudet.
Thanks, Will. Hi, everyone. Jackie Beaudet. We have a great panel today. This is sort of top of the game here with a really interesting topic. So I'm really excited to kick it off. I'm going to read bios so that I don't butcher them. But we have Kate Buck. She's the co-leader of McCarter and English's sports and entertainment practice, and co-managing partner of McCarter's Delaware office. Kate advises schools, athletes, and organizations on NCAA compliance, NIL issues, eligibility issues, and she represents clients in all issues related to it. And next we have Ira Gonzalez, also co-leader of McCarter and English's sports and entertainment team. He's also co-managing partner of McCarter's Miami office and a former NCAA athlete himself. Ira counsels clients on NIL issues, licensing, sponsorships, and rights of publicity matters. And last but certainly not least, we have Mike McCann. Mike is visiting professor at Harvard Law School and associate dean of the University of New Hampshire's Franklin Pierce School of Law, where he leads the Sports and Entertainment Law Institute. Mike is one of the country's foremost authorities on sports law and governance. So thank you all panelists for joining us. As we talked about earlier, we're all lawyers here, but we're going to speak straight, right? And let everybody know what's going on. So Kate, lots of activity in this area. Before we get into the nitty-gritty, can you just kind of give everybody an overview of, the landscape and currently what's going on with the whole world of NIL?
Sure. So probably most people that are watching this webinar are familiar at least with some basics of historically the NCAA prohibiting players from earning income based on their name, image, and likeness. And that changed several years ago. In 2001 was really sort of a big breaking case where that changed through the Alston case. But really, I think, with that background that folks mostly know that historically this wasn't something really available to student athletes. Let's bring it to today, or at least recent times. The House settlement was major litigation that was settled in June of this year. It took effect in July, and basically it was the culmination of years, I believe 5 years of litigation with multiple plaintiffs against the NCAA related to antitrust allegations, basically that there were restrictions on the competitive market, and because of their inability to earn money on their name, image, and likeness. And ultimately, the NCAA and the named plaintiffs, let me back up because it became the settlement applies to a large class where parties needed to or could opt in if they wanted to. But basically, the named plaintiffs and the NCAA and the major power conferences within the NCAA ultimately reached a settlement that did allow three basic things. There's a large back pay component that provides a $2.5 billion pot. There's some nuances there of how that's distributed, but basically to athletes that missed out on opportunities to earn on their NIL from 2016 through September of 2024. And so there was the back pay component of that, which is actually on hold because there are several appeals pending on the approval of the settlement. Then there was a revenue sharing portion of the settlement, which essentially allows colleges to, within the NCAA, to share up to a capped revenue, a little over 20 million, with the amount to go up incrementally as revenues go up. But basically it's a revenue share that allows them to pay their athletes directly. And that is to be distributed at the college's discretion for the most part. And then the sort of other main component of it is allowing college athletes, current college athletes and future, to earn on their name, image, and likeness. But there was a development of something called the College Sports Commission, which in conjunction with Deloitte is operating something called NIL Go, which is basically a clearinghouse to review the NIL deals and maybe someday actually approve some of them. So that's basically where we are. And Jackie, I think, you know, I really love visuals. And so the way I think about this in general is that, like, you know, at a county fair or a school field day or whatever, there's like those dizzy bat races. And I think what's really going on here is they had everybody like spin around, you know, put their head down on a bat and spin around, and then they just sent them off. And it's like, I hope that maybe someone grabs you and steers you in the right direction, because everything basically, and what we're all about to talk about, is that there are so many uncertainties and things are changing constantly. And so it was sort of like this huge settlement. Oh, this is really big news. This is amazing. But is it really? And so much of it is unclear. And it's athletes and universities and really everyone are sort of left to just like spin off in a dizzy haze and figure out what direction they're going in. So
So let's talk about direction for a second. That's an interesting point. So, you know, Ira, I'm curious from what you've heard and seen in your practice, has anyone really given a clear vision for long-term vision for college sports or even high school sports? Any stakeholders, NCAA, the Congress, I mean, anybody?
I think clear is in the eye of the beholder, but I mean, the situation in college sports is a complex blend of both this reactionary crisis management and the emergence of this new competing long-term visions that are articulated by all these different stakeholders. But the key issue is there's no unified vision. Instead, there's several competing frameworks that, my perspective, have been hastily deployed, right? And that's where we are today. And I'll call the reactive mode or crisis management part of this, and that's the immediate landscape. It's dominated by reactionary responses that are largely driven, like Kate just mentioned, by this judicial and legal defeats that have dismantled the NCAA's historic amateurism model. I won't spend too much time on the House settlement because Kate just did a great job of summarizing it, but that's a direct reaction to prevent catastrophic antitrust liability. And that's how the House settlement, frankly, came to be. Then you talk about conference realignment. It was a frantic expansion by the SEC and the Big Ten as a defensive financial reaction to secure media rights, maximize revenue, which is driven by the immediate necessity of funding new athletic compensation models that they're all getting familiar with. And then the governance overhaul, the NCAA's approval of this new D1 governance structure that grants the Power Four conferences, ACC, Big Ten, Big 12, and the SEC, this weighted voting power that's 65% on some major committees. And it's a necessary reaction, again, to this decentralized power and streamlined decision-making in an environment where frankly, the wealthiest schools were already acting independently to a certain degree. There's competing long-term visions, right? And although there's a number of chaotic situations right now, we take each individual stakeholder to understand where they're coming from with their vision, long-term plan, and what the core principle is of that plan. The NCAA and the power conferences have this post-settlement model that, again, we just went through a moment ago with Kate talking about a system of institutional revenue sharing with a cap and new streamlined, again, governance structure that is giving the wealthiest schools this de facto control. The core principle there is stability and revenue control. And that's what that model is frankly honed towards, to maintain that competitive balance to ensure financial sustainability of non-revenue sports. And you've got Congress with two competing legislation, the SAFE Act and the SCORE Act, which you can label them as the Republican position and the Democratic position. The SAFE Act being the Democratic side on federal regulation, athlete welfare. That's a vision that involves nationalizing NIL rules, enabling collective media rights negotiation, mandating long-term athlete protections, medical care, scholarship guarantees, preservation of Olympic sports. The core principle there is uniformity, athlete protection, creating a single clear set of rules for the industry while explicitly protecting non-revenue sports and student athletes from financial excesses. The SCORE Act, on the other hand, is seeking to protect or adopt antitrust immunity and employee shields. So it's a competing vision that would grant the NCAA and conferences an antitrust exception in exchange for establishing rules while explicitly and immediately shielding them from classifying athletes as employees. And the core principle with this feature is legal protection, the quote unquote amateur shield, even though amateurism is long gone in college sports. And it restores the NCAA's regulatory power and definitive block on legal challenges. Then you got the student athletes that are in the bucket of employee status. This is not a uniform or overall viewpoint, but generally speaking, they want employee status and collective bargaining. The reality is, and I think there's a consensus on this, that student athletes don't have a seat at the table, right? They don't have a say on some of these regulations or provisions that are being implemented that affect their careers. So it's a vision that focuses on full recognition of athletes as employees in revenue sharing sports, granting them the ability to potentially unionize. And of course, labor rights, fair compensation, that sort of thing. So, in a nutshell, the current state of college sports is not one of a simple reaction. But rather a state of conflict between these competing long-term visions.
Competing, but with a sort of undertone of protecting sort of athlete, seat at the table and wages and things of that sort, right? So it's interesting. We're talking a lot about this House settlement, right? That just happened in June. And Mike, maybe you could kind of give us a high-level overview of the House settlement. And from your perspective, I'd love to hear, what do you think is broken in it? What's not working? Why are we in this place where everything is so chaotic?
Yeah, and thank you for having me, and to follow the great comments by Ira and Kate. The problem with this system is that it's trying to create a league, basically a pro sports league on the fly. And what we're seeing, I think, corroborates the core accusation against the NCAA member schools, is that they really are businesses that are competing, and they will do whatever they can to compete. And that includes paying athletes to go to the colleges. And they've created a system of constraints through the House settlement, which may be well-intended and which might eventually work, but were put into place abruptly. And there isn't enough time, I think, for those who are involved to really get a sense of the rules. So what's happening is that the College Sports Commission is sort of thrown into action to review NIL deals to see that they're representing actual NIL, which would be the use of an athlete's right of publicity, versus pay for play, which the NCAA continues to prohibit. But it's tough to do that. It's tough to do that on the fly. It's tough to do that when the market moves faster than the review process. And also when the review process is being ignored, what happens? Are there any consequences? Does anyone get punished? If not, a school doesn't want to be disadvantaged. An athlete doesn't want to be disadvantaged. And I also think it's interesting, we're in this era now where the NCAA is allowing former G League players to play basketball. That's a pretty profound point, where athletes who are unionized employees are now college athletes. Why can't NBA players or WNBA players or pro soccer or pro baseball players who might have remaining eligibility, why can't they suit up as well? And now we, of course, see college athletes suing to stay in school. That's a pretty striking event, that it's not entirely the House settlement, but the House settlement created a league. And as Ira noted, the players weren't at the bargaining table. It was negotiated by attorneys. And if you're an athlete, you don't have the same vested stake in this, perhaps, that others, if they were at the bargaining table, might feel. So there's a lot of chaos. There's a lot of fast moving pieces. And I would think that, to me, the biggest takeaway is that the market is moving much faster than the regulator. And that's true, of course, of other industries. But it's hard to see the NCAA kind of catching up with the market.
So let's talk on the College Sports Commission for a second. And you mentioned sort of the lack of power there. If they don't have the power to reject deals, so what is the deterrent then for sort of noncompliance with what the current rules are?
I guess we'll find out. I mean, certainly the deterrent would be a rejection of a deal, and the deal would have to be renegotiated. That's the immediate deterrent. But there are certainly comments being made that athletes are not worried about the College Sports Commission, and that business partners who are not part of the deal. I mean, this is the College Sports Commission. It had a good idea in the sense that there's an arbitration system in place. It looks like a lot of thought was put into it, but the enforcement side of it, to me at least, isn't really clear. And does the school get in trouble with the NCAA if it doesn't follow the College Sports Commission? I don't know. Does an athlete get in trouble? Does an athlete lose eligibility? Should they? What about the company that wants to pay them? Is there any consequence for them? Is the arbitration process followed? And we know, generally speaking, arbitration is a great way to mitigate against the risk of litigation, because claims are preempted unless they first go through arbitration. But what happens if we see litigation brought by those who don't believe the arbitration is valid because they're not signatories to the arbitration agreement? A lot of interesting features here. And again, I don't want to fault. I mean, this is done on the fly. It's complicated. It's like a really hard law school exam, right? You got 3 hours. You got to take it. It's not going to be perfect. But the problem is that there's so much notice of what's going on that it kind of had to be perfect to work.
Yeah, in terms of notice, it's interesting. I mean, there's an article every day, right? 2, 3, 4 articles every day. This morning was, Ohio State Court enjoined a prohibition in the law that had prohibited high school, right, level players from
I think that was
receiving
Mike's
NIL.
article. Wasn't that Mike's article in Sportico? There was a
You're
link.
right about it. Yeah, thank you. Thanks, Kate. Thank you for reading.
Check out Sportico if you haven't
Click on
yet.
that
Mike
link.
is a frequent
Please click
publisher.
on the link.
But it's I think we think about it as at the high school level, and now it's not. I mean, excuse me, at the college level, it's in the high school level. But these really interesting novel theories about, and one of the athletes had said, well, I'm playing right against these athletes who do have access to these deals, and I'm in one of these 6 states that doesn't, right? And so why is that fair? Why is it fair to me?
Jackie, to that point, think of all the young people who can make money on their NIL.
Yep.
Influencers. I mean, I have a 5-year-old, so I see all sorts of things on TV and there are kids and their parents clearly making money through the use of a young person. Forget a high school athlete. We're talking kids,
Right.
musicians, entertainers, actors. Why are athletes not? I mean, it's kind of weird, right? Your classmate is making money through use of their NIL, but you can't.
Right.
It's a strange landscape.
Yeah, and I think there's a fairness and equity component to it that most people sort of seem to understand and be in support of, but litigation, right? That's the name of the game when you have new rules and untested rules and you're trying to figure them out. So Kate, what is the current, sort of landscape of litigation? What are you seeing are the litigation trends, and what do you think is coming down the pike?
Well, one thing which I mentioned earlier, which is, of course, that there are appeals pending to the House settlement itself. So that's still subject to potentially be overturned or back to the drawing table on certain pieces of that. So that's probably going to be a while before there's really any finality there. And like I said, in the meantime, the back pay isn't being paid. It's not being distributed. And then on the other side of it, the going forward aspects of it, it's just everybody going wild. So they're complying with it as if it is final, which is how it works. I mean, right now, those are the terms that were reached. So there's revenue sharing and there's all the NIL happening. So that's going to be a long time, but we'll see, there still could be some shakeups there. But like you said, I mean, there's so many offshoots and everyone's hearing about the different things. And then people are really creative and they really think of all the different ways that maybe this isn't fair to them. I mean, and that's a good thing. I think there's access to so much information right now and people are thinking for themselves and saying, wait a minute, okay, wait, that wasn't fair to me. And so you're seeing things like the Pavia situation, the quarterback at Vanderbilt, who there's now this JUCO waiver rule, basically because of his litigation. And I think he may even be like a potential Heisman contender or arguably Heisman contender at this point. And so it's paying off that he got this extra year of eligibility and he's earning money. But other people, there have been several pieces of litigation on that same basis, essentially, that they're seeking this extra year based on either having had a JUCO year or something else at another year at a non-NCAA school. And the thing about that litigation is that there's this waiver the NCAA said, they would put into place based on that. But it's only for athletes who competed last year and that would have been their last year of eligibility. And they get one extra year this year if they qualify for the waiver. So it's very limited. I mean, so there's going to be more litigation, like, okay, well, what about next year? And what about the year after that? And like Mike mentioned, the G League player that's now playing. So I guess I'm sort of crossing back and forth between what will happen and what is happening, but that's one of the big things right now is over eligibility and extended eligibility. And of course, you mentioned the high school. That's obviously not with the NCAA, but that's the Ohio, whatever their athletic association is called. There's still litigation pending. The Johnson matter, I believe in Pennsylvania, Eastern District, Pennsylvania, that's related to employee status. So there's pieces of this all over the place. And I guess if I could back up for a second, including that as much as the House settlement related to alleged antitrust violations, some of the appeals are based on the fact that it basically ignored Title IX completely. So that's, an aspect of this. But it also resulted in just some new restrictions. So there are still antitrust considerations there. So it's, again, all over the place.
Two things I wanted to sort of circle back to in your comments. One is the appeals. So if those appeals are successful, what happens to the current state of NIL? I mean,
ultimately, the whole House settlement could be upended. They could go back to the drawing board for approval of a revised settlement of sorts. But I mean, it may just ultimately be upended, and then there will be more chaos because, well, what's been happening all in the meantime? There was no, enforcement in the meantime. Athletes who signed on didn't get their back pay, and you're going to be right back where they were with the NCAA getting sued left and right by individuals who feel that they should have been entitled to earn on their NIL in past years. So it's a past problem, it's a future problem, it's all a big mess. And the NCAA, I think, has just I don't know what their intentions were in trying to solve the problem. I mean, it feels like Mike said, it's just hard to keep up with the market. And so I don't know if anyone could have done it perfectly or really kept up. But I do question if the need to maintain control and power hindered the ability for there to actually be a true workable settlement.
The appeal, if I may, that I am highly following is the Pavia case that Kate mentioned. Interesting enough, that's currently in the Third Circuit, and you can't say enough the value of this player to a university that's now been on the football map, and now they're top 10 in top 25 polls. This Third Circuit case is still pending of whether the extra year of eligibility was proper or not. And it would be interesting if that decision is overturned in the middle of the season and there goes a value for that organization or that school. It'll be interesting how that plays out, but it highlights the value of NIL.
Right. And so to that point, right, so if that's a 1-year issue now, Kate, you're touching on the fact that maybe there's a creative argument to be made that it could go on beyond that.
Well, I just think, I mean, again, then you have, there's probably going to be litigation over things like a G League player coming back, and there might be litigation on both sides. Maybe someone else sues and says, well, wait, you're bringing professional players back into college, and now there goes my roster spot that I had. I mean, I don't know, but people will come up with ways that they were wronged.
Yeah.
And there's just not
Michael,
a clear framework, so.
yeah, I mean, it's fascinating. I'm thinking, Michael, you're at universities, and there's these cases talking about whether athletes are employees, right? And what sort of benefits they should or should not have as a result of that. If this is successful, if these lawsuits are successful, how does a school absorb that, right? Like, what does that do to, I mean, we're seeing enrollment decline, right? So what happens? I mean, how does the school absorb that? What are the ripple down effects there?
Yeah, and I'm speaking as myself, not obviously not my school. I don't want to.
Correct.
On that.
Spoken like a lawyer. I love it.
I gotta watch. My roles here. This is a tough time for universities. I would begin with that. It's a really important point when we think about what universities are thinking. There's the great enrollment cliff, that there were fewer babies born in 2008, and that it's going to last a while. That enrollment's going down at colleges across the country, and colleges are competing now more aggressively for a smaller pool of US students who are of college age. That will mean less revenue for tuition, less money for dorms, less revenue for meal plans, giving more aid to applicants, which of course is good for the applicants and their parents, but not so good for schools. So there's that going on. There's the fact that research grants are being cut through the current federal government. There are also more limitations on international students coming to the United States to study. So all of these things are happening that hurt schools. Now we add what we've been talking about, which is the House settlement, that schools can opt into a system where they pay up to $20.5 million a year just for athletes. Couple that with as Kate mentioned, the fact, and Ira as well, that college athletes might become employees. And if they're employees, what kind of employees are they? There's the Johnson versus NCAA case, Jackie, that you mentioned earlier. That case argues that college athletes are employees under the Fair Labor Standards Act and accompanying state law. So that would mean they get paid at least minimum wage and overtime pay, like other student workers, right? So it would be treating college athletes like other student workers, some of whom get paid to go work at games, which is interesting, right? There could be a student worker who's paid to get a ticket when you enter the arena, or to go get a soft drink from them. They get paid, but their classmate who's on the field doesn't. And then there's, of course, the prospect of college athletes becoming employees under the National Labor Relations Act or an accompanying state law. That would allow them to unionize. It invites the question of how would that work? Who is the bargaining unit? Is it just like at Dartmouth, for instance, the men's basketball team would have been the bargaining unit, but is it maybe a conference level? Is it the men's basketball team, or is it all athletes in a school? So there are a lot of unanswered questions, but for universities, this is a worrisome event. Now, some might step up to say, well, they actually meet the test for employment. If you look at control by the university, there's a good argument that they are employees. So, a lot of worrisome moments for university presidents right now, and the prospect of paying more for sports, it may be rightfully so, is scary.
Yeah. Does that trickle down to ticket sales and merchandise price increases and food increases?
How about student fees, right? I mean, that's another way. And I think some schools have said they've raised prices to offset expenses for paying athletes. Now, again, that doesn't mean it's a bad thing. It could be, you could say that's a good thing, that they should get paid, and that for years they weren't paid. And this is a way of kind of the law catching up with the realities of the market. But at the same time, if you're a university president, that's not what you want to hear, right? You want to be thinking about, oh, I'm worried my enrollment's going to go down by 2,000 students. That's a ton of money. My researchers just saw a grant cut. Our enrollment of international students, particularly graduate students, and a lot of international students pay full, right? They're paying full tuition. So it's even more cost prohibitive for schools. Yeah, I mean, it's sort of like weighing the economics versus what's right.
Yeah, and it's an interesting sort of conundrum because you have schools possibly thinking, well, if I can attract some great athletes and I can get some good sponsors and some good names, then my enrollment might go up, right? And so then, or
Right.
you have this sort of strange, um, you know, conflicts kind of thing about where your priorities lie. And then and are you in a situation where you have sort of student athletes and then employee athletes, and does that create a divergence between students who are kind of doing the same thing?
Yeah, and if athlete, and also the why are they employees? So if athletes are employees because of control, and that money, that whether they make money doesn't matter. So in the Dartmouth case, I remember the lawyer Jake Rusby said, it's because the Dartmouth said, well, they're not making money, the basketball team loses money. I mean, that's not the test for employment. Amazon lost, I think, $2 billion a few years ago. It wasn't like their workers are demoted to interns, right? I mean, they're still
Right.
employees. The test isn't how much money you make. Under employment law, it's really about control. That's a fund, and whether there's a bargain of exchange. And in the Dartmouth case, the players argue that they get priority admissions to the school, that they get per diem, that they get equipment, that they get access to healthcare that other students don't get, and that's part of the bargain for exchange. So, but if that's the test for employment, that means all sorts of athletes could be employees. It's not just Power Conference football. The test would seem inclusive of many others.
Right. That's interesting. So I just want to go back to Title IX for a second, because we hear a lot about Title IX and sort of how that potentially impacts the House settlement, and potentially how, on a go forward basis, how the funds are impacted by sort of Title IX thought processes. So Ira, let's unpack it a little bit. We have a $20.5 million cap. Projections are that 90% of that goes to men's sports. So can you talk a little bit, just so everybody's on the same page, about that cap, and who's the first plaintiff, right? The plaintiff, and who do they sue? Is it the NCAA? Is it the school? I'm curious about your thoughts about sort of what the Title IX implications are of all this.
Sure, as if the NCAA didn't have enough problems with the employment status of athletes, here comes Title IX, right? I mean, just to answer your question directly, I think the obvious defendant, or first defendant, is the individual member school. And that's because of their receipt of federal funding. So this 20.5 million revenue sharing that primarily goes to the school, but the NCAA and the conferences will likely be tied in as potential defendants as well. So not to bore everybody with a law school analysis of Title IX under the educational amendments of 1972.
Wow.
Michael definitely has better credentials to do something like that than I. Not bore anybody. Yeah, I'm talking about actually give this sermon. But it applies to any educational institution that receives federal financial assistance, which includes virtually all NCAA members or member schools. The university is the entity that receives the federal funds and is directly responsible for Title IX compliance. And the schools are the ones with direct control of where this 20.5 million would go, even if they had the ability to raise that kind of money. We're talking about the wealthier schools that are likely are already implementing this and have the financial wherewithal to be able to do this. But they're the party with the authority to decide how the money is allocated amongst its sports programs, whether, for example, 15 million goes to football, 1 million goes to women's basketball. And the reality is, in the NIL world, the monetized sports, if you may, are football and basketball. And I was a baseball player, so I'm throwing baseball in that bucket. And then there's everybody else in the world of college sports. There's a proportionality requirement in Title IX that requires that athlete financial assistance must be substantially proportionate to the percentage of male and female athletes participating in that institution's athletic program. So a plaintiff's argument in these Title IX cases will be that there's a distribution heavily favoring men's sports, violating this essential standard. That's as simplistic as I can make Title IX, which is litigation that goes on for years and years. and there's existing precedent, right? So all major Title IX compliance lawsuits regarding financial aid, facilities, and opportunities are filed directly against the member school or the university. On the NCAA and the actual power conferences or conferences in general, while the NCAA doesn't directly receive federal financial assistance, it and the conferences could still be named. And although success against them may be a little bit more limited, they're primarily going to argue, going back to the House settlement, this antitrust defense, where Judge Wilkin explicitly noted that the case was about antitrust and that the settlement does not compel a Title IX violation. However, she left the door open for future Title IX challenges against individual schools. I mean, the other practical defense is the NCAA's strongest defense, frankly, is that the cap is a maximum and that the allocation within that cap is a choice made by the individual school, thus placing liability back on the institution. The NCAA is doing a little bit of finger pointing in these cases, and they eventually will, pointing and trying to divert liability towards the member school. But the core Title IX challenge is that female athletes, again, dictates what I mentioned a moment ago, is proportional to participation analysis. So if a university has, for instance, 55% female athletes, then female athletes should receive roughly 55% of the total institutional financial aid. If $20.5 million pool is considered athletic financial assistance, and 90% goes to male athletes, you can see the problem right there. The school is in direct violation of the proportionality standard, regardless of which sport generates the most revenue. Now, I think there's also an issue about whether schools are waiting for to see how the lay of the land plays out, but I'll stop there.
Well, we all might be retired if they wait for that. I'm curious, and maybe everybody could touch on this, but is there a way for a school to sort of, I mean, until you can't, until you wait, right? You can sit and wait, or you can go, and people are going to go. Is there a way for them to, in your minds, have a compliant program here, or are we just walking into, is this revenue model just walking into problems? Kate, what do you think?
They could choose not to do the revenue sharing model, which many, some have opted out. And some, even if they technically opted into the settlement, again, it's a cap. So they're not required to give out the full amount. But I think that, yes, they could do it more equitably, but they also could do it to support their athletes in finding opportunities of true NIL, the outside NIL. So they could use that money in other ways, and they could use it to, help their athletes across the board. They could use it for financial literacy programs. They could use it for guidance in entering into contracts with these NIL deals, because athletes are getting some terrible advice in some instances, or no advice, or, they're just signing whatever's presented to them and they're getting into issues that way. So, I think there are plenty of options that schools can implement to not get into Title IX trouble. I mean, again, starting with simply just not participating and paying their athletes directly, but even if they are going to do that, I think that there's ways to do that more equitably.
Michael, what's your thoughts on this one?
Yeah, I agree with both Kate and Ira that these are clearly going to be susceptible to Title IX challenges. As Kate referenced earlier in describing, that's one source of challenge to the settlement itself that will have to be litigated, including at the Ninth Circuit. I think for schools, schools love to say that they treat people equally, right? That's always been part of the ethos of higher ed. And this creates tension with that, right? Because you want to treat, if you're a university president, you want to treat your students equally. You want to make sure they think they're being treated equally. So a system where most of the money goes to football players will be instantly inequitable mean, forget the Title IX piece. I think it's really how the campus community reacts to it. How do faculty react to it? Do they like a system where the school is paying more money to men playing a sport than women playing a sport? Even if it is compliant with Title IX, and there are arguments that it is, there are arguments that these distributions of funds, whether it's part of the settlement that it was an antitrust case, or whether the revenue share is a reflection of the use of the athlete's NIL, at least that's part of it, that NIL is an individual characteristic, it's not part of a group. And if the quarterback gets more in revenue share than the bench player on the volleyball team, that's okay. That we would expect the quarterback to get more in that scenario. So there are defenses to it, but at the same time, I think it's going to be tough for at least some presidents to sort of talk about being equitable with students and then at the same time, pay the quarterback more than everyone else. It's certainly going to raise some awkward conversations.
Public too, right? These things, that's the
Yep.
first conversation to go public. So, Kate, I'm a football star at a college, middle of the country, and I come to your office. What are you telling me are the fundamental protections I need to have as I start on this journey?
Gosh, that's a really broad one. So all the things you need, it's all situational. I mean, and that's the thing actually, as litigators, Ira could tell you this too. We take each situation as it is and look at the specific needs or, what the specific circumstances are and figure things out from there. But I mean, just generally speaking, reputable guidance, at each step of the way. Their athletes are not employees right now. And so obviously there would be different considerations if there were employment concerns, and it would be, what the protections were in their employment agreement. In this, it would really be more about our athletes are looking at the provisions of their potential NIL, deals, their deals with the schools for rev share, but also their true NIL. And a lot of those contracts are incredibly one-sided when they are presented. And it's tough because the athletes are not, except for a select few, they're not really in a position of having high bargaining power. So we're really just looking at all the ways that we can protect them so that what they bargain for is what they get, so that they don't, they sign on the dotted line, they enroll as a student, they're there on campus, and then next thing, for any reason whatsoever, the school says they've actually decided to terminate the agreement or the collective or whomever the deal is with. And that's what we're seeing a lot, is that there's just these one-sided, schools can just terminate for any reason. And there just really aren't a lot of protections for the athletes. So we're trying to at least guide the athletes to understand what leverage they maybe do have and to use that, and also look outside of those agreements. If they are making some money or they have some means, they should be looking at getting other like financial advice, looking at insurance related to their health, their ability to continue playing the sport that's earning them money. I mean, there's all sorts of things, and we're not the ones to provide, advice on those different topics. But I think even beyond our sort of legal role of looking at the agreements or looking at what rights they maybe have to eligibility or appealing, something related to a deal that didn't go through or things like that. We also do provide guidance sometimes just on a professional basis, kind of more like, these are some other aspects maybe you want to be consulting professionals about. So.
Anybody else have anything to add on that one? No. All right, so 15 minutes left. About two things I wanted to touch. One, collectives. Ira, talk to me about collectives and how they're impacting sort of what the current landscape is.
Sure. I mean, some can argue that collectives were the driving force behind the House settlement to control the payments directly to athletes versus this third party entity that is quote unquote uncontrolled. But you can argue that it's what allowed and facilitated the NIL system altogether. It professionalized booster programs to a certain degree that have existed for ages. But collectives seem to be operating to a certain degree as de facto paymasters of college sports. They do, I
Meaning,
believe they strengthen the market concept. You know, there's demand, create it. But again, the opposite argument is whether it's blurring the lines of accountability. Some felt that NIL, the House settlement, would require a complete elimination, or would result in a complete elimination of collectives. Some have folded into a marketing department within the athletic department, but the majority are still in existence today and effectively are supplementing the $20.5 million cap that is part of the House settlement. To give the example right here at the University of Miami with Carson Beck and the payments that you know he's received. You know, but I do believe that there's a financial demand for this kind of system. How it's regulated by the CSC, the College Sports Commission. We saw competing policies come out where they're rejecting certain collective payments and then turning around and allowing them to go through with a $600 cap that requires review. So in essence, you know, collectives, I think, are here to stay for the foreseeable future. Whether the increased cap year in, year out makes them less futile, I don't know. I don't have the crystal ball to say one way or another. But they are likely the ones driving a lot of the market forces behind winning now, right? And a shorter time period for holding on to a high-paid coach or high-paid player that isn't performing. And there's also complications about what happens if a player doesn't get a payment from a collective that is the university or the member school part of that potential litigation. There's so many contractual issues that come out of this that are still being played out. It's such a new environment that I think Michael may be able to put together an entire class on collectives
everybody go to Harvard and take
for
his
the
class.
foreseeable
Right?
future. So that's my take.
Yeah. So last question for the group, and I'd kind of like to hear from each of you on this. Michael, let's start with you. You have a blank sheet of paper and you can design a stable model for college athletics. Where do you go? Do you go employee-based system? Do you go pure NIL market, hybrid revenue share, something else? I'm curious.
Yeah,
What would you design?
thank you. And now, since you're all going to my class coming up, you're all going to be guest speakers. So now that I'm going to go into it. So I think employment and collective bargaining are ultimately essential ingredients, because a world without that will lead to more and more litigation. And I know universities and conferences and the NCAA don't want college athletes to be employees, but the reality is that that permits a steady flow of antitrust litigation. Now, you know, maybe Congress acts in a way that changes that calculus, but we have seen 36 bills in recent years regarding, you know, that are met with a lot of fanfare. Right, the member of Congress gets a lot of media, introduces it. I mean, there are hearings, there's lobbying, but nothing ever seems to happen. And we're a year away from the midterm. So my guess is that, and Ira laid out those two bills really well. I think we have reason to be skeptical that they're going to advance to become law.
Mhm.
And without that, it's going to be another year of litigation. I think a model that has some sort of bargaining between the athletes and the partners would be the schools, the conferences, the NCAA, to me makes a lot more sense. I mean, look at the NBA, NFL, Major League Baseball, NHL, WNBA. I mean, yeah, they have labor issues, but at the end of the day, they largely avoid the steady flow of litigation that we're seeing now. So my advice would be have a system that is predictable, that's consistent. The system now isn't predictable. The system now you can't rely on. It changes every day, as we talked about. That doesn't strike me as a good system for anyone.
lawyers, right?
Well, that part.
Kate, Kate, I know you have some interesting thoughts on this, so why don't you share?
Yeah, well, first, most interesting, I need to comment on Michael's mention of, these bills that aren't going anywhere, because it reminds me of that song everyone learns in like elementary school about I'm just a bill, whatever. And it doesn't go anywhere for that. Like, it's a bill. It didn't, there's more steps, there's more verses to the song that I'll spare you from, but like, it has to go beyond that. So that's where we are with so many of those bills. But yeah, I mean, look, I mean, as a lawyer, my job isn't to do this, but I can't help but share my opinions. Obviously, like I said, advise people in the situations they're in, and deal with the frameworks as they are, and whether there's litigation to be had there. But I definitely have opinions, and I tend to go, I think, more toward the just market model. Let the market set itself. And again, mentioned earlier that I don't see why the schools have to actually be paying the athletes. If the athletes are free to earn whatever money they can on their own name, image, and likeness, why? I mean, the school is sort of the vessel or the basis that gets them the ability to earn that. But what they're getting, is hopefully an education. They're getting that experience of college. They're getting, I think, back to what traditionally, college sort of values and experience were supposed to be, and just exposure to the world, and so many different things. And that allows them to then capitalize and earn their NIL. But I don't think the schools need to be involved in actually paying them. And again, I think what the schools should focus on, and not just for their athletes, but for their student body as a whole, is using, because they do make money from athletic revenue, using that in ways that helps prepare their students for professional careers after college, whether that be in athletics or not. And when students can, for the athletes, when they can earn money during college based on their NIL, and they actually know what to do with it, and they can maybe invest or start businesses, or maybe they're helping out family members, whatever it may be, but give them the actual tools and resources to then make the best of that. So for whatever they're doing next. So I get, and Michael makes a really good point. I mean, there are pitfalls there as well, and potential future problems. But again, that's not really my problem. I just like the idea of, let the market set itself.
This is just, you had your way.
Yeah.
Ira, how about you? Let's finish up with you.
Yeah, I know we're limited on time, but I like a little of both worlds. I'm more in favor of this hybrid revenue sharing type structure. And the NCAA athlete in me appreciates the fact that someone in that position today can put a little bit more money in their pocket that may really help them long term. Whether at 17, 18, 19 years of age, they've got the mindset to be able to make those lifelong type decisions, I question. But I just think a pure employee model is a little too complex for college sports, especially again due to the Title IX and logistics of public institution. There's a lot of passion behind college sports. I mean, we didn't have a chance to touch upon state laws that are conflicting with NCAA policies, and those are driven as a competitive edge by schools, state schools in those states, that want to be able to get that athlete that's deciding between the University of Florida versus University of Alabama. And if their state gives more benefits than the other, I mean, it really is an interesting time. But I also think a pure NIL marketplace is a little too volatile. It may be extremely destructive to competitive balance, but that's just my perspective.
Well, if you three can't figure it out, then we're all stuck and we're all in trouble here. So, well, thank you all for today. This was really, really interesting. I learned a lot and wrote a lot down to research further. I really appreciate your time. I hope everybody enjoyed it. And if you have any questions, please reach out to anybody on the panel and we'd be happy to connect further.
That's great. Thank you so much. And Kate, I'm just a bill. Yeah, I'm only a bill. And I'm sitting here on
Capitol Hill. There we go. You're just only a bill.
Thank you so much. It's really fascinating. Jackie, thank you for moderating. It's a fantastic discussion, really interesting. I learned a ton and I thought I actually knew something. So this has been really, really good. And thank you so much for taking time out of your day to support this and be on this webinar. And thanks to our audience. I appreciate it.
Thank you.
Bye.
Thank you. See y'all later. Bye.